all these distinguished defendants' attorneys speak, and I saw this morning that the majority of you are also defendants' attorneys. I was reminded about a story from my youth, and it's very quick. When I was a young child, about 5 or 6, my family had a small farm in upstate New York, and it was a nice, idyllic place. And in the fall, pheasants used to come right up on the lawn by my parents' house. And on one occasion, my uncle Abe, had come to visit, and Abe was an avid hunter. And one morning he awoke and saw these beautiful pheasants on the lawn and grabbed his gun and went down to shoot them. My twin brother ran up to him and aghast and said, "Uncle Abe, what are you going to do?" He said, "Well, I'm going to shoot the pheasants." And he said, "But Abe, we don't shoot them, not when they come to visit. So I'm only visiting here." All right? I want to, before I talk to you about some key contract provisions, go back to what Saul Walensky was talking about for a minute in products cases, and when a plaintiff's lawyer in a labor law scenario might want to bring a products case. Other than if you have an insurance problem, which is obvious and you want to bring one, you might be faced with a scenario where you have a 241-6 case, and there's no 240 case. You're bringing the case after the Aries decision, and you don't know whether you have an implementing industrial code regulation. There may be none. Usually there's one that you could stick in and it has, you figure it'll work out, but you're not sure if you'll be able to make out a prima facie case. In that scenario, you might want to bring a products case. For instance, I have a case at the moment involving a crane where a worker's hand was drawn into the fleeting sheave, which is a mechanism that winds up the cable on an extension of the crane. I had my doubts whether there's 241-6 will hold the various contractors in, because I'm troubled about an implementing regulation. So I brought a product suit against the manufacturer on a design and failure to warn theory. So that might be a situation where you have to go with a products case. One other thing about what was discussed before is someone had, I think Ira, when he was speaking, was considering what the next great wave of mass tort cases will be. I feel compelled, by the way, to tell you after listening to him, I've never handled one of these carpal tunnel cases. All right? So, but some of you may have been reading about these cellular phone and two-way radio cases. I think there's going to be a lot of cases with them. I've been approached already by people who in their job, I haven't taken any of the cases because I think it's too early and none of them were that serious injuries. People who use these two-way radios with the stubby antennas, which are an option on many of them. The standard Motorola two-way radio, for instance, comes with a book that says you can get a stubby, which is a small antenna. It's easy to use, but when you're using it, it's pointed directly at the head area, and there's a question about whether radio waves can cause these damages. I think that you're going to see a lot of cases in that area. Let me talk to you for a minute about key contract provisions, primarily from a plaintiff's viewpoint. You heard David before, and he's already spoken to you about the indemnification provisions and the insurance provisions, and they're important, and you've heard about them. I don't want to go into them in detail at this point. One thing that Tom mentioned about the DJ actions, we have them in this area, in the metropolitan area as well. I've never had a case stayed because of a DJ action, and my philosophy is let defendants fight all they want. I love it. It's the best thing that can happen to me, you know? And that's unfortunately carries over at trial. It seems to me that, and I'm not on the defendant's side, but looking at it that way, if defendants could present a more cohesive front, these cases would be somewhat more difficult for us plaintiffs, and because in so many instances, it becomes a sit-in for us. We put a witness on, ask them enough to make out our prima facie case, and then the defendants go up and go crazy with each other. And we're just sitting there, you know, stay out of it. And it builds our case, and it makes it even a better case than it otherwise might be.